Hello, I'm Jason Rhodes, an attorney at BSKB. I would like to discuss Intellectual Ventures versus Motorola, a Federal Circuit decision issued on September 13, 2017. Intellectual Ventures sued Motorola for infringement of U.S. Patent Number 7810144, relating to the transfer of computer files directly between two or more computers or computing devices. The asserted claim is written to claim a communications device configured to perform certain operations, resulting in transmission of a file to a second communications device. The claim also recites that the second communications device is configured to perform various operations, including transmitting a delivery confirmation to an authenticating device, which, in turn, is configured to generate a delivery port, including a delivery time. Intellectual Ventures argued that Motorola's customers directly infringed by using phones to send text plus photo messages using a multimedia messaging system, and thus Motorola was liable for indirect infringement. Under this theory, Motorola's phones met the limitations of the first and second communication devices, while the limitation of the authenticating device was met by service centers operated by the wireless service carriers. At trial, the jury found the asserted claim to be infringed and not invalid. Motorola then filed a motion for judgment as a matter of law, but the district court denied this motion. On appeal, the Federal Circuit found that Motorola was entitled to judgment as a matter of law regarding non-infringement. Because the parties treated the asserted claim as a system claim, the Federal Circuit's 2011 decision in Centillion Data Systems versus Quest Communications was treated as the governing case. Under Centillion, the court concluded that to use a system for purposes of infringement, a party must put the invention into service, i.e. control the system as a whole and obtain benefit from it. The district court had held that Centillion only requires the infringer to benefit from the system as a whole. The Federal Circuit disagreed, holding that under Centillion, proof of an infringing use requires the patentee to demonstrate that the direct infringer obtained benefit from each and every element of the claimed system. As such, the critical question was whether there was substantial evidence that Motorola's customers obtained benefit from the generation of delivery reports. At trial, Intellectual Ventures presented evidence that when the phone sent a message, a delivery report was generated to authenticate the transfer, and the accused phones were capable of displaying a received confirmation. However, most of the service centers discussed at trial only stored the reports and were incapable of transmitting them. Further, by default, the phones were configured not to request a report, and there was no evidence of record demonstrating that the customers knew the delivery reports existed or could be obtained. A practice tip based on this decision is to try to avoid writing system claims, especially those including components that would be in possession of multiple parties. If a system claim is necessary, make sure each component clearly benefits the end user. Thanks for joining me, and I hope you learned something today. Stay tuned to bskb.com and on Twitter at bskbip for more upcoming videos of interesting cases and other commentary on intellectual property.